Hey, everybody, welcome. Um, This is Nick Morgan from ICAN, coming to you live from Paul Hastings' office in Atlanta. I want to start by thanking Paul Hastings for hosting this event. We're in front of an enormous live studio audience, so thank you all for coming here in person. Those of you online, you'll notice there is a little widget where you can ask questions. We hope that this is conversational, and so feel free to lob in a question at any time. ICAN board member Dara Albright is actually generously offered to field those questions and forward them to us. So again, welcome. This is SEC regulation by enforcement, how to reform the SEC, what is the issue of regulation by enforcement, and why and how should it be addressed. Very briefly, I'd like to welcome my co-panelists. So we have on my right, Tim Pagliara, founder of CapWealth. Tim, you want to give a few sentences about yourself?
Been in the industry 40 years. CapWealth is a boutique investment advisory firm. We manage $1.6 billion on a discretionary basis. Kind of an academic shop. I've got 3 CFAs, 2 CPAs. I'm an attorney, not a master's degree. We kind of consider ourselves a poor man's family office. And really glad to be here to have this opportunity to tell our story a little bit.
And we'll hear more about your story in a few minutes. We're first going to hear from Ken Herzinger, who is participating, who appears over my shoulder here. Ken is a partner at the law firm of Paul Hastings, the firm that's hosting us here in Atlanta. Ken is also Paul Hastings' co-chair of their investigations and white-collar defense group, which is a mouthful to explain that if a Paul Hastings client has an SEC issue, Ken is one of the people they call first. Ken is formerly with the SEC's enforcement division out of San Francisco. Ken, thank you for joining. Any words you'd like to say about yourself?
Yeah, great. Thanks, Nick. Really happy to be here with everybody. So I as Nick said, am former SEC enforcement attorney like Nick. And these days, past 20 some odd years, I spend my days defending investment advisors, broker dealers, other regulated entities, public companies vis-a-vis the SEC through either examination proceedings or enforcement proceedings, investigations. And glad to be here. The topic is certainly something we encounter on a day-to-day basis. So definitely prevalent in my practice, and I think has significant impact on our clients.
Thank you, Ken. And the topic again is SEC regulation by enforcement, which requires some unpacking, which Ken will do for us in a minute. A little bit about my background. So as I mentioned, I'm the co-founder and president of ICAN, which is a nonprofit. ICAN stands for Investor Choice Advocates Network. I practiced with Ken at Paul Hastings for a number of years and formerly was at the SEC, and observed while defending people in SEC actions something missing, which is that most people can't afford to litigate against the SEC. Most people have to settle. And what ends up happening is because most people have to settle, the SEC builds up this track record of what they view to be precedent. And you have sort of an incremental growth in the SEC's authority and the scope of things that they're consider themselves responsible for. And so we founded the nonprofit to counter that. That mechanism I just described, where the SEC enlarges its jurisdiction and the scope of its authority through one-off cases, has been described as regulation through enforcement. But before I go too deeply into that, Ken, can you give us a little masterclass on regulation by enforcement, or what it is, the industries that it's impacted most notably, and maybe why it's a problem?
Yeah, absolutely. So, what does regulation by enforcement mean? So I think, the place to start is with the basics. So the SEC is a civil administrative agency. Its powers and authority are therefore set by Congress in federal statutes. And the SEC can adopt rules interpreting those statutes within the bounds of the laws. But SEC rulemaking requires the SEC to go through a public notice and comment period, which allows members of the industry to express their views. And the policy behind this is to give registered entities and the public fair notice so they can ensure that they're able to comment on how it could impact them, but also to make sure that they're aware of what the rules are so that they can remain in compliance with the federal securities laws. And in its essence, this is what we all think of as due process, our, constitutional right. And sometimes, as we saw recently in the Fifth Circuit, the SEC exceeds its statutory authority to adopt those rules. And as with the private funds rule that they proposed, the Fifth Circuit actually struck that down, said they exceeded that authority. And that's the branches of government working the way they were designed to make sure that as an administrative agency, the SEC is kept in check and able to enforce the laws where it has authority, but not exceed its bounds, as Nick was mentioning. But sometimes the SEC decides to end run that process and takes legal positions on new industry trends, novel legal topics, or issues that arise to set policy without any formal rulemaking or a notice to the public or that notice comment period. And often the positions that it takes when it does this exceed the SEC's authority or conflict with existing law. And these cases usually result in settlements, as Nick mentioned, that the SEC then relies on to make policy and use as precedent against others in other cases in the future. And just to pause there and make it crystal clear, the SEC's charges and settlements in other cases are not the law and they are not precedent. It is not a court case and is not binding. And typically, in fact, virtually always, these settlements are done because the defendants either don't want to continue to litigate because they don't have the funds, as Nick mentioned, could be to avoid reputational damage, for lots of other reasons. People will settle, and the settlements will typically say it's a no admission settlement. Therefore, they're not admitting to the facts. What's troublesome, though, is that the SEC, as Nick mentioned, has not only cited these settlements when trying to negotiate future settlements, but they actually cite them themselves in their own court papers, and then others actually in civil litigation rely on them as such. And the courts even mistakenly refer to them from time to time. And this is what we've all come in the industry to call regulation by enforcement. And so what's wrong with this? Well, there's several things wrong with this. I mean, first, obviously, the SEC is overstepping its authority under the law, but it also leaves regulated entities and the public without clear guidance on what the law is, how to comply with the law. It sometimes results in unfair or inconsistent treatment of various market participants. And then ultimately, it actually weakens the public trust in the SEC because the public begins to believe and perceive that the SEC is simply being arbitrary and unpredictable. So a number of commissioners, current, including Commissioner Peirce and Ueda, as well as other former commissioners, have actually dissented formally and written statements about this recently, expressing their skepticism and displeasure with the practice. But it continues. And Tim's case, which I know we're going to talk about in a moment, is a perfect example of regulation by enforcement. It arose out of, just a sec, the backdrop for their conversation we're going to talk about, rose out of what we call an SEC sweep, where the SEC will target many regulated entities in a field related to a specific subject. So in this case, it was the share class share disclosure initiative sweep, and it resulted in several dozen settlements. And because of that, kind of created like a de facto regulatory rule against the use of 12b1 fees, even though the SEC had never issued any rulemaking on it, and they had no guidance, issued to the industry before that. Another recent case, which really caught a lot of press, was the SEC's $35 million settlement with a company called Activision Blizzard. So in that case, the SEC settled charges against Activision for allegedly failing to maintain adequate disclosure controls and procedures related to workplace misconduct. But as Commissioner Peirce stated in her dissent, the SEC's disclosure controls and procedures were not designed to regulate workplace misconduct. That that's an employment issue, and that the SEC's charges were unprecedented and had no nexus to federal securities laws. But yet this $35 million settlement is now out there, and public companies are scratching their head and thinking and asking me and people like Nick, do we now need to change our entire controls and process procedures to make sure we're compliant with, the federal securities laws? No one wants to pay $35 million. So that's the backdrop of the conundrum and how the regulation by enforcement by the staff plays out in the real world, and some of the negative repercussions.
So Ken, I don't want to catch you unawares with a question we didn't rehearse, but one of the areas, and this came up in congressional testimony as recently as yesterday, one of the industries that's been complaining most loudly about regulation by enforcement is the crypto and digital assets space. And I know you have represented a number of clients in that space. Is there some regulation by enforcement going on with regard to the SEC's positions as they affect digital assets?
Yeah, I believe so. And the reason why I think there's now objective evidence that there is because you have federal district courts coming out different ways on the same issue. The Article 3 judges are finally getting these cases in front of them, and there's the proof that there are no bright line rules in this space is that you have very sophisticated judiciary looking at very similar fact patterns and coming out different ways. And, ironically, the SEC keeps saying, well, it's bedrock law. It goes back to the 1940s. The lines are clear. Everyone should know. But yet they ignore the fact that they themselves have issued non-formal guidance multiple times, including a 25-page essential white paper treatise a couple of years ago on how to comply, much of which they've now disregarded and ignore in their own, litigation positions. And the other thing that has created an issue, and I think, shows the regulation by enforcement, is that they've taken different and inconsistent positions in these litigations. So the SEC's own interpretation of how the law should apply to crypto and which crypto token is a security or not a security, or is a note, sometimes varies depending on the complaint you read or the lawyer at the SEC that brings the case. And obviously, it's a burgeoning industry, and if the SEC wants to regulate it, and I think everyone agrees, that no one's saying there should be no regulation, then there needs to be some clear guidance, comment from the industry that actually operates in the space, and then let's publish something, that people can actually comply with.
Yep. And not to go too far, that was a question in the audience.
Yeah. Well, it's more of a statement, really. So that's my world. I own a cryptocurrency exchange startup here in Atlanta, and I spent 30 years on Wall Street. I was never on the compliance side, but I don't have any blemishes with FINRA. I'm not going to start now. Ken, one of the points you said is one of the most, and this is not how it's going to come out, so just let me go. It's so asinine that you said this. I mean, and I agree with what you said, but you talked about looking back to the 1940s for regulatory clarity. That would be akin to using horse and buggy legislation to govern how our streets work today. It's one of the dumbest effing things I've ever seen in my 30-year Wall Street career. I think that the reality is for the SEC to even be trying to figure out a security and the Howey test and all this, again, makes zero sense to me personally. I think this is a CFTC thing because to me, they mirror commodities and or currencies a lot more than they do securities, but whether it is or isn't, the real resolution to me should be, and I'm not really towards beefing up the government even more, but they need to get into modern times and come out with a digital asset regulatory body. And that's the bottom line, because they constantly are trying to force square pegs in round holes. And the absurdity of this whole thing is Gary Gensler. And what drives me insane about him is the guy's a huge blockchain advocate. He knows Bitcoin, he likes crypto, but the guy has ended up looking like a total jerk because on his watch, he's allowed this genie to get out of the box, and this genie is not going back in. And so now he's playing Johnny Law Dog, trying to shut down everybody. And I think the way you guys phrased this whole conference is very nice. I really think it's more about litigation by intimidation. Because the first time somebody gets anything from a government, we had an IRS audit, and I like totally freaked out. I like almost lost it, right? And we haven't had anything, thank goodness, everything's fine with us. But the reality is we're all working in this regulatory ambiguity where nobody really knows. It's like, please just come out and provide it. And the last thing I'll say is at least as far as we go, an exchange, the broker-dealer component comes up. And I tell people, look, I try and take the SEC's language and use that with regards to why, and we have a very, very unique setup, but I try and use their own language why we're not registered as a broker-dealer, because we're not a natural person, corporation, or organization that trades, here's the operative word, securities on behalf of ourselves or for our clients, right? The SEC has come out and deemed about 68 coins or tokens of securities, and I've redacted all those pairs, so we don't offer those. But it's mind-boggling how Hester Pierce, we know she's like the biggest, crypto advocate out there. And thank goodness you have Cynthia Loomis, and you have a lot of other Congress people that are coming on board. Obviously, both presidential candidates have now done a total 180, and that's fine. We know it's coming, but I just wish the SEC would kind of stay in their lanes and have another regulatory body step in. But would love to see some insight from you on that. I'm sorry, I just hogged your
Yeah,
guys'
no,
time.
so a couple of comments. First of all, it strikes me when I talk to people, I've represented clients in the crypto space, that this issue is not limited to crypto. This issue of the SEC exceeding its bounds, failing to give clarity, failing to give notice, and it's not limited to Gary Gensler. This, regardless of what happens in November, this will continue. This is an institutional issue that goes well beyond crypto. But thank you for the comments. I don't want to go too far down that. I mean, crypto is a very good example of the SEC regulating law enforcement. I think one of the points we want to make is it applies in a lot of other areas too. So if it's all right, we're going to leave crypto for the moment, and there's a lot more to be said on that. We should probably do a whole panel on that alone. But
Yeah, we could. Yeah.
But so Ken, thank you for that, those comments. I'm going to turn though to get some of a description from Tim, and as Ken mentioned, so Tim and his firm CapWealth were caught up in this sweep that had it represented a change in position by the SEC, and it was pointed at registered investment advisors. And it had to do with disclosures around the types of mutual fund share classes that clients were being put in, and whether a disclosure about whether a firm may receive fees versus shall receive fees, whether that's an adequate disclosure. So I don't want to steal your thunder, but just to set up your story, the SEC investigated Tim and CapWealth, decided that may receive instead of shall receive was a fraudulent statement, filed a lawsuit in federal court, and just again to set the context, the SEC had been making this same allegation around the same time to dozens and dozens and dozens of other firms. This was industry-wide practice. No one thought was illegal, and these are firms that pay a lot of money to compliance people, a lot of money to outside counsel to figure out how do we not break the law. Everyone was doing this. SEC changed position, but for purposes of what we're talking about here, regulation by enforcement, rather than putting out a rule, putting out some sort of amnesty program, the SEC just started telling firms, we're going to sue you. And almost every firm said, we don't want to be sued, we'll settle, we'll pay a fine. So you go to the SEC's website now and they brag about this 12B1V sweep. And they, I think they collected something approaching $200 million in penalties.
Well over.
Dozens and dozens of household name firms, small firms, big firms, every part of the country. Tim, to his credit, said, that's not fraud, and we were compliant, so file your lawsuit. Okay, is that enough of a setup?
Good setup.
All right. You take it from there.
I try and simplify things as much as I can. And to Ken's point about regulation by enforcement, it reminds me when I was in law school, and the joke every year at the end of the semester was, this year we're not going to change the questions, we're just going to change the answers. And that is very much how the SEC works in the RIA space. because they could have very easily said, use the word shall, and they would have avoided $5 million worth of attorney's fees on our part, their part, expert witnesses, and 2.5 years worth of business disruption. So how do we get to that point? Well, in 2000, I started my business. I had a broker dealer and I had an RIA, and I was actually piggybacking off of another firm's broker dealer and regulatory setup. And in 2009, I decided to do my own. So I did. And we had an audit, SEC audit. It's their first audit. We had both the FINRA and the SEC in my office for 2 weeks. They took over a conference room about half the size of this, drank our coffee and used our paper and pencils. And at the end of it, they made a series of recommendations. But essentially, we maintained the same disclosures that we had in 2009. Fast forward to 2000, in the fall of 2019, which was our second audit. And in 2019, they said, I've got bad news for you. And there was an amnesty program. And they said, why didn't you go into this amnesty program? I didn't do anything wrong. Why would I admit to murder if I didn't murder anybody? There's not much to discuss there. And that was it. And there were 3 auditors. The one was a feeder for the Atlanta Office of Enforcement.
Yeah.
And he came in and have you ever had someone come in and do this? And he handed me a piece of paper and he said, I've got some really bad news for you. And then went on. And the other 2 were embarrassed. The audit was completed. We got a cleared letter in January. There was nothing. I mean, we're clean as we could be. And then we got 5 days later, we got a letter from the enforcement division saying that they were investigating us. So in the middle of the pandemic, we had to do depositions. The 12B1 fees were less than 2% of our total revenue. And I said, we had a broker dealer and we had an SEC registered investment advisory firm. We shut down the broker dealer in 2018 because in that 18-year period, there was an evolution in share classes in mutual fund industry. So we used to get a 25 basis point trail, and that's all we collected. It was the reason I had the broker dealer, because I could offset those expenses the clients were incurring through a discount of our other advisory fees. And that correlated to 100% when we went through the entire thing. They took the position that everything was wrong. And we had our own experts. I said I have 3 CFAs, 2 CPAs. Our litigation support would have cost us $1 million if we had had to hire an outside firm. That's how closely we worked with it. And so the industry went from F1 shares to F2 shares, which eliminated the advisory fees. The F2 shares paid Charles Schwab and other broker dealers a 20 basis point trail. And then they came out with F3 shares. The F3 shares eliminated the 20 basis point trail. So when you convert these share classes, it's a very time consuming process. And I was explaining earlier, the SEC took the position that you just do it automatically. Well, you can't, because in tax law accounting, for example, if you've got a client that owned MIT mutual fund for 35 years, each one of those investments is a separate tax lot. So they wanted you to just roll it into average tax law accounting, which definitely works to the disadvantage of the client. And ironically, in 2018, when they passed one of the tax acts, they eliminated the deductibility of advisory fees. And everybody was trying to get around it. So at that point, 12B1 fees had actually become the most tax efficient way for clients to incur fees, because they were embedded in the mutual fund company's tax deductible, state, local, federal, the whole bit. But the industry had pushed away from that. So they took this position that we were bad people. By May of 2020, they hit me with a Wells notice. That's a real special day. Where
Can we pause and tell what a Wells notice is?
yeah, a Wells notice is the notice that the federal government has to give you if they're getting ready to throw you in jail or bring litigation against you. And it's a special day in your life when you get one of those. And despite the fact that I had never had a violation in 30 years of business, they were going to ban me from the industry for life. That was the threat, you know,
Right.
and
Take away your finger.
and because the statute of limitations was running, they were doing this and threatening an immediate lawsuit unless we signed a tolling agreement. The tolling agreement gave us an extra 30 days to respond under the procedure that we had. So I put together the dream team. I had one of the best litigators in the country, Gino Bolso, in Nashville. We reached out to Brad Bondi. Brad was kind of an adjunct advisor to us. You know, we were under such a time constraint. Brad got John Macy, who's head of the securities law division of Yale University. I think he was in line getting donuts in Nantucket on a Sunday morning. And we all got on a conference call. He agreed to take it on
As an expert.
as an expert. And we just went to work on them. And by the time we got to trial, we had exhausted every avenue that you could for settlement. We'd been through 3 court-ordered mediations at that point. The trial started. They excluded John Macy as an expert because of a case in Philadelphia. The judge just followed that ruling. It was incorrect, but there's nothing you can do. You're right in the middle of starting a trial. We had to go forward with it. And we just took them to task.
So,
I mean,
quick question, was the trial in an actual court or
Federal
was it
court,
in their, you know, their special?
federal court, Judge
Jury
Waverly
trial?
jury
Yeah,
trial
okay.
in Nashville, Tennessee. And, you know, there were some humorous parts of it, you know, just 2, and I don't, they rifled through our client base, trying to find someone that would testify against us.
Can you imagine all your clients getting a subpoena from the SEC?
Oh
And
my God.
thank God we've got these wonderful people that we've worked with. They called us, you know, and they said, and I had one attorney that they were doing this with, and they were literally trying to entrap him into saying something. But he brought all the stuff into me after the fact. And so they had this one little old lady, she was 81 years old. I'd taken care of her parents all their lives. She left the firm in 2016 after she got her inheritance. Her husband, you know, had his own way of doing things, which is fine. They live in Lilburn, Georgia. They bring her up. I haven't had any contact with her since 2016. They bring her to Nashville. They pay all of her expenses and everything, spend 45 minutes in trial developing her testimony. He sits down. My attorney stands up, says, Miss Lampley, just had just a couple of questions for you. Do you know why you're here? No? No one ever explained to you why you're here? No. Would you be surprised to know that the dollar amount in question related to all the trouble you took to come from Lilburn, Georgia to Nashville, Tennessee to testify in this trial is $67? Yes, that would surprise me. And so they get back up. You know, at that point, I think the best thing you could do as an attorney is to shut up on the other side. But they didn't. He got up and he tried to stumble through some type of rehabilitation. She gets off the stand and she walks down, and she's got to walk between the 2 tables. She reaches over, stands up, and gives me a hug. And the second one, and we got all this feedback from attorneys, and this is why we're here. Not everybody's got $2 million in the determination to fight the SEC when the outcome's pretty ominous, you know, if you lose. And so we are, you know, we're going through all this, and we deposed their expert. Their expert's this guy, his name's Gary Gibbons, And he had been paid over $700,000 by the SEC on these cases that had never gone to trial. Not one of them had ever been to trial. We deposed him, and he's this adjunct professor of finance at some school out in Arizona, and he's in his 70s. He has an RIA that has $9 to $11 million and 15 clients in it. And he has a partner that's helping him write this expert opinion report. The report written by the guy, this guy had a personal bankruptcy. He had to take a Dave Ramsey personal bankruptcy course to satisfy the requirements to exit bankruptcy. And he had non-disclosure issues of civil actions that were against him.
This is their expert?
They're experts.
Oh my God.
Yeah, the other side. And so we took Gibbons' video deposition. We referenced all this in January prior to the November trial. And, you know, it was just breathtaking. And you could tell he never said how much the SEC had paid him to do. He just wouldn't answer the question. And it was pretty obvious he didn't write the report. So my attorney, Gino, he asked him, he says, well, when you wrote this part of it, you did write this, didn't you? And he said, yes. Well, let me refresh your recollection from your video deposition that we took in January. And he lied. I was just right there. And all of a sudden, the guy breaks down and he says, well, I was having a really bad day. I'm diabetic and I think my blood sugar was low. The judge looks and says, this time, maybe we should take our afternoon break. They send the jury out. The in-house expert at the SEC almost was held in contempt of court for violating the exclusionary rule because he was on, came back the next day. Well, you know, I've got a few answers I'd like to change. And I watched the judge and I'm going, oh, here it comes, here it comes. The next thing he does, he sends the jury out and the judge turns and now he's asking him questions. And I mean, when he's about ready to put the hammer down on him, he says, how many times have you ever testified in court? Most is the first one.
This is the SEC's internal expert witness. Yeah.
And the judge just says, all right, bring the jury back in. And that was it. And it was right after that we had the fourth court-ordered mediation. It was right before Halloween. The judge said, look, I know you guys have plans. You want to get back to your families. We're going to let you out at noon. And we still haven't found any procedure under the federal rules where they can order a mediation in the middle of trial. But federal judge says you do something, you do it. And at that point, they tried to divide and conquer. And I mean, I was like a bear in a cage being fed with meat on a stick at that point. I mean, I was pretty fired up. That didn't go well. We resumed trial. Took them 45 minutes, not guilty. And, you know, but when you go through something like that, you got three things that you're dealing with when you're, from my perspective, and that's why this is so important. It's the money. I had the money. Obviously, I'd rather burn it in the street than, you know, pay it on litigation with the SEC. That's the first part. The second part's business disruption. Because I've got my entire team is focused on all this. And the third part of it is, you know, no matter what happens, now all this is expunged, it's ab initio, as if it never happened on our disclosures. But you can still Google, you can still see things from the trial, things like that. There's maybe 1% of people in the back of their mind, what did they do? Well, you know, they get off on a technicality. It's your reputation, you know. And I've got two trademarks that I have developed over the years. The first one's provable integrity. The second one's sophisticated simplicity. And we just, you know, our reputation's not negotiable. And it was a bear. You know, Mike Novogratz was on a program a few months back, maybe 6 months ago. And they were talking about all the regulatory fines and everything that's coming in crypto and some of the things that you alluded to. And Novogratz said, look, Jamie Dimon's paid over $30 billion worth of regulatory fines at JP Morgan during his tenure as CEO. And these firms price it into the cost of doing business. It's bad for the consumer. It's bad for the business. And I'll close with this, Chairman Powell yesterday, when he was talking about, he called it a recalibration of monetary policy, and they were making fun of him because he used the term, I think, 9 to 11 times in his 10-minute press conference. The SEC needs to be recalibrated. I'm working with Senator Haggerty. We'll have an opportunity when the smoke clears after the election. And we want to propose legislation to strengthen some of the existing legislation, but even go beyond it. If the SEC brings an action like this, they lose, they pay.
Yeah. Oh, that's
And
great.
that will, and then they need to be accountable for the efficiency. We did a 30B6. They didn't think that they even had to have their deposition.
This is a deposition where you get to depose the SEC's
So-
witness most knowledgeable about whatever.
About whatever.
Right.
Yeah. And they didn't think, because it was the SEC, they had to do, we had to go through a motion, and the judge said, oh, yes, you do. We came down here, they're over in the Salesforce building, and you go in there, it's a pigsty. It is disgusting. It was embarrassing that this is the United States federal government. They've got the enforcement sign and everything. And this guy who has been head of the Southeastern office of the SEC for 15 years, with the SEC for 30 years, Georgetown law graduate, he had no knowledge whatsoever of any of the important cases regarding damages, nothing. And he was represented by 2 of his staff attorneys. And my attorney kept him going as long as we could, no breaks. And I mean, he's hanging himself. He hung himself all morning, and they're over there just, oh no, what am I going to do? He comes back after lunch, and all he did for the rest of the day was engage in ad hominem attacks against me personally, against my firm. And so we couldn't use this. Unfortunately, we couldn't use the deposition because the judge ruled, well, if you use your part, then he gets to use all the other things too, which was hearsay nonsense. But anyway, that's, I'm glad to be here. Glad this is a passion. It's something that everybody in the legal community should get behind, that has to deal with these enforcement actions, because it's the only way we're going to make some change. And it really is shameful that your government can treat you like that.
Well, we need more people like you that are willing to stand up and fight.
Yeah.
That's, I think, I think it's great to have legislation or make the SEC pay if they lose, but we need people that, have the guts to basically take them on. So thank you for that.
Yeah, we do appreciate the fact that you were willing to put your money and your reputation and your time and effort into fighting against unfair claims by the SEC. As you pointed out, not everyone has the financial resources to do that. And that observation is why we started ICAN. It's a 501c3, it's a nonprofit designed to provide pro bono legal assistance to people in SEC matters that have a potentially precedent-setting issue at stake.
Can I ask a quick question about
Yeah,
that?
of course.
So usually, people don't have the money, even businesses don't have the money to defend,
Right.
so they go and get insurance to do that
When you can.
when you can. But most people that will be going into business, especially if they're going into anything related to the SEC or related to crypto, for sure,
Right.
D&O insurance, try to go get it, it's
Right.
gonna be expensive.
Yep.
But even then, they're gonna be getting, most of the time, duty to defend coverage.
Right.
Which doesn't put them in control of the outcome, it puts the insurance company, and they're only motivated to settle.
Right.
So my point is that I'm just curious, are you seeing that most people are actually handing these things over to the insurance companies are settling, they're using it as a,
That question is so good.
I
Yeah.
have an umbrella policy.
you had an umbrella.
Yeah. $3 million worth of attorney's fees. If I was ever issued a Wells notice, and when they issued the policy, they said if it emanated from the broker dealer, which had been shut down,
Yeah.
it's
As
not
opposed to
covered.
the investment advisor. You got the two
Right.
sides.
The broker dealer hadn't been in existence for 2 years. And this didn't emanate from the broker dealer. It emanated from the investment advisory firm.
So now
Took
you're
it-
fighting, now you're
they
fighting
fought
with the
it,
insurance company.
and I had to
You
file
get money to-
I had to file a lawsuit against the insurance company. I've got 5 judges that are clients. One used to be the Chief Justice of the Tennessee Supreme Court, so I'm not going to malign them, but they're not financial experts. And they don't understand a lot of these different things. And so the judge bought off on the insurance company's argument. He gave them summary judgment. And we took it to Circuit Court of Appeals. They denied the appeal. And so there was another $150,000 down
Yep.
the drain, and no coverage.
Ken, did you have a comment on the insurance?
Yeah, unfortunately, D&O coverage it often results in a lack of coverage or very little coverage. So the first reaction by D&O carriers is typically, number one, deny the claim. Then even if you get the claim covered, if you want really good lawyers, like Tim had, they say, well, yeah, we're going to pay about half their rate because that's our rule and we pay the going rate in the geography. And who knows who these lawyers are that they find, but they work for about $100 an hour. And no good lawyer works for the rate they're willing to pay. So you end up getting about half of your costs covered. And then, God forbid you lose, they point to the, intentional misconduct and fraud exclusion, and then they deny coverage on whatever penalties or judgment you have to pay. So unfortunately, my experience over the years is it's certainly not the coverage you think you're buying up front, and often leaves you hanging in the wind. And as Tim said, you sometimes have to litigate just to get the coverage. So doesn't leave most people in a great position. And the fees in these cases, they're complex, right? And you need experts and things. And so it's not like a sort of a contract case or a normal dispute. So the fees and costs can mount, really quickly. It leaves a lot of people in a bad place, which, obviously ICAN is trying to fill that void. And we do a lot of pro bono work with ICAN, which is, part of a great relationship we've had for a long time. And that's why we do it, is because we try to lend our expertise where we can to people who can't afford, to write those briefs to the appellate courts and the Supreme Court, et cetera. Sort of that thing.
Can I just ask one more?
Yeah, and then there's a question in the back.
Oh, I'm
right
so
now.
sorry. I'm
Right.
screw you up.
Oh, no, I was just gonna say, my experience has been similar. I do a lot of work for you with D&O insurers, footing the bill for directors who are ever investigated. And however much insurance you think you have that's enough, it is not enough. I mean, a $5 million policy can be gone before the investigation is finished when you've got a lawyer for each director and a lawyer for the CEO, a lawyer for the CFO. I mean, that money goes so fast. And if you tell them on the front end, you need $50 million, they're like, that's crazy. We can't afford that. That way too much. And, I'll tell you, it is not enough. $5 million is not enough. $10 million probably isn't enough. If you've got an SEC investigation and then a shareholder class action, that money is going to be gone.
Yeah.
And you're going to be left, on your own, having to look to guys like them for your defense.
And that's assuming you have coverage.
That's right. That's assuming you have coverage.
But you had another question now.
Yeah, I'm just interested in it didn't really occur to me until you said it, but the jury, and in the jury selection, I mean, there's no way those people are financially literate to the extent that they have to be to make a judgment in a case like that, right? Or are they?
I think
No.
what happens at a certain point, in my experience with that jury, at a certain point, their inherent sense of fairness took over, and they started to recognize the absurdity you know, where you had these objection, you can't, you know, they were trying to, they did everything they could when I was on the stand to keep prior knowledge of that audit, for example, out of place. And then she brings up this piece of paper and said, do you see right here where it says that just because we didn't catch you doing something in 2009 doesn't mean that you're, you know, that gets you a get out of jail card for free. And they just started to look absurd, you know.
And I think a lot of the cases that go to trial where there's a jury turn on issues that people do understand. Like,
Yes.
are you honest? Are you deceptive? I mean, you boil it down to that issue. And, you know, in your case, the issue came down to, I think, whether may receive fees versus shall reserve fees. Were you trying to be dishonest or deceptive in that? And I think at some level you can, the jury is able to sort of get through the complex issues and get to the issue of honesty.
The jury foreman
Not in every
told,
case, but
jury foreman told me afterwards, he said there were a number of people that said, I don't want that firm representing me. You know, so, you know, it's, you gotta win them over.
Yeah.
Yeah.
you got a question?
Yeah.
I have two, but I'll just focus on one to respect everybody else's time. I'm very focused. Hey, good to see you, man. I'm very focused on crypto. Okay, that's my first love. Hello to my crypto people. So the first question I have is about the overturn of Chevron. And ever since then, it appears there's been a heavy change. You made a comment about Gensler. He's my least favorite person, but he did vote in the ETH ETF. He did vote in the Bitcoin ETF under pressure after the court overruled him, right? They forced his hand. It was the other two Democratic appointees that still voted against it despite the ruling. So my question on the Chevron situation, the post-Chevron reversal, is what are you seeing, and I know this goes beyond crypto, right? But what are you seeing now at the agency level? Because even today, the CFTC got, and I'm not an expert on it, but they got a bit of a slap, not related to crypto, relative to kind of certain things that you can't just say, hey, that's ours. You know, so I'm curious about what you think the environment is now and if it's changed and how so.
Yep. Ken, I'll go first, but then you
Yeah.
certainly should weigh in on it. So just so everyone knows, Chevron is an old doctrine that just got overturned in a Supreme Court case called Loper. And the Chevron doctrine says that judges, where there's an ambiguity in the law, and the agency has an interpretation of that ambiguity, judges were bound to adopt the agency's interpretation. So that was judges giving so-called Chevron deference.
Like tie goes to the runner.
Tie goes to the-
At the agency.
Yep.
And it was limited, but,
Yeah.
and so now the Supreme Court said, no, judges need to exercise it. They can still take into account the agency's view, and they should, but they must come up with their own independent conclusion and not defer to the agency's conclusion. So obviously an important case, Supreme Court case in the last term, and it applies not, it wasn't an SEC case, it had to do with fishermen. But Ken, tell me what you're seeing. I, in my experience, the SEC very rarely invoked Chevron deference. And so there were not a lot of cases where the SEC was telling judges, you must defer to us because it's you know, under Chevron, that's the rule. There were specific instances. I can think of one where it actually came up. One case, actually, that our former partner was involved in, an insider trading case, where it was the question is whether a person is liable for insider trading if they're merely in possession of material
Yeah,
knowledge.
possession versus use. Yeah.
Yeah, or whether they
Yeah.
had to prove that the person used the information.
Yeah.
In that instance, judges were all over the map, and the SEC passed a rule that said mere possession is enough. And they, in a particular case, asked the judge to defer to their judgment on that ambiguity in insider trading law. The judge did defer. So, and so that issue will no doubt come up again, and you know we'll see what happens. But I
Yeah.
have not seen Chevron make a huge difference in SEC cases. But Ken, your experience may be different.
Yeah, I'm really interested to see how it plays out. It does come into play when you're in litigation, you know, during the investigation stage. You don't have a judge to weigh in, so it's irrelevant. But I do think it'll make a difference. And just to make it clear, it's not that the tie goes to the runner. The tie goes to your adversary. So this is as if Nick and I are litigating against each other, and because he's the SEC, the judge favors him. And so essentially what the Supreme Court did was, no, you're two litigants in front of an independent tribunal. You're on an equal playing field. I'm not going to favor either side. Just because Nick decides he interprets the law a certain way doesn't mean he should get the benefit, right? And over me or vice versa. Neither one of us is Congress. We didn't create the law. And so why would your opponent get the ability to interpret the law they're suing you about? I mean, it never made sense to me. And the Supreme Court, I think, just kind of brought it back to equal playing field. So I don't know. I could see it having an impact in complex cases where, like in crypto, there is little law or conflicting law, and the SEC has taken a position and a rule that a judge just simply doesn't agree with. Doesn't make any sense, and now they won't be bound to adopt that view. They can take it under consideration and disregard it, as Nick said. But I applauded the move because it basically just puts us back to equal footing.
I want to give the people online. an
Well, but we're
opportunity
getting, not so much a question, but some
Okay.
great comments.
Okay.
And so, and one basically, come in and says, this literally sounds like a thought crime, you just being it. And really, how do you get over it? What are you supposed to do, go and have your memory erased so
Right.
you don't know
Yeah.
the insider? I mean,
Right,
that's crazy.
Right, on the insider trading piece. Yeah, that's
Yeah.
true. Well, there's a case right now involving a theory called shadow insider trading.
Yeah.
It's
It's a whole nother.
Ninth Circuit out where Ken is. We're going to get some more clarity, and the SEC will not be able to invoke Chevron deference on that in that case. Before we wrap up, I do want to talk a little bit about a couple of ICAN cases. One that will be, I think, resonate with the crypto folks, and it's the case Ken mentioned, or one of the cases where Paul Hastings is ICAN's co-counsel. We have clients who were sued. There's no claim of fraud, no claim of investor harm. The only issue in the case is whether the financial instrument at issue was a security under Howey, that case from the 1940s we were talking about before. Shockingly, it's not a crypto case. The financial instrument is called life settlement arrangements. This is an instrument that 30 years ago, the DC Circuit Court of Appeals held was not a security and said, therefore, if it's not a security, the SEC does not have jurisdiction. Right. The luxury, if you're at the SEC, is that even though that was the DC Circuit Court of Appeals, their home court, they're free to bring other cases in other circuits and disregard that holding. And that's what happened with our clients out in Los Angeles. And that case is up on appeal. But this shows that even when there's a win, sort of cabining in the SEC, in this case, this particular financial instrument, the SEC gets to try again and try again and try again. So these clients are three people accused of selling this at a time when there was no registration statement, no exemption, and they were not registered as securities brokers. They can't afford counsel, and if we had not stepped in to represent them, they would have settled or just lost the litigation. So we're litigating that case. And then since we're in Atlanta, I'll bring up one. We do represent a client in Atlanta. I don't know if any of you know Marlon Williams. He's at the Atlanta Blockchain Council. So he was supposed to be here, but he's probably busy. But anyway, he represents a community of users of a thing called Pulse Chain token. The SEC filed a lawsuit in that case, and we represent the community of users was not sued, and this will
Richard Hart.
find this funny. We do not represent Richard Hart. He's the named defendant.
Yeah.
But the SEC, in addition to naming him as a defendant, named as three named defendants in the complaint software programs as
One of
defendants.
the smart contracts.
Crazy.
That's smart
Yeah.
contracts.
So Marlon and his community was concerned that if the SEC wins, even though they're not involved in the case, that there will be adverse impacts on the community of users. And so we represent them, again, pro bono, to make sure that no one's going to stand up for the software in court. No one's going to represent the software in court. So we're there to make sure that that the court addresses that complexity in the absence of any lawyers.
But on that court case, what's the precedent for them with that, like from their point of view?
Oh, so from their point of view, they argue that this software protocols are something like a business association. And a business association can take the form of a partnership or a corporation.
Yeah.
Those are, abstract bodies. And so
Yeah.
they're arguing that this software is like a business association.
Yeah. Believe it or not, there's actually some bad precedent out here in Northern District. The Okie Dow case, it's actually CFTC, but they did the same thing. They sued the Dow under a theory of unincorporated association, like a joint venture partnership. And they've gotten past the initial stages. The judge actually said, yeah, you can do that, which is wild as it sounds, so that's a path the regulators are taking. And my concern about it is it sounds kind of goofy or selling software, but it would give them a hook to go after the community, right? So you think about it, that's the next step in that chain. And so they're essentially leads them to go after the very same people they purportedly are trying to protect, which is, the whole issue, right?
And Ken, you should take a look at the prayer for relief in that SEC complaint. They're not asking for the normal injunction that just prohibits people from violating the law in the future. They're actually asking the court to prohibit people from using the software.
The software. Yeah,
It goes way beyond anything that are
Yeah.
entitled to. So anyway, that's another case here in Atlanta where we're representing. The case isn't filed here, but Marlin is. Well, we're just about out of time. So for those of you who are here in the live audience, we hope you can join us for a beer, a glass of wine, and a snack. For those of you who are participating remotely, too bad you missed out. And, we thank you, Tim. Thank you so much.
Oh, thank you.
Kane, thank you for allowing us.
Yeah, really enjoyed it. Thanks, everybody.